Thank you very much, ladies and gentlemen. May I invite first my guests on the stage, starting with the senior most. Justice A.K. Ganguly, former Supreme Court judge, joins us. Please give him a very big hand. Come, Justice Ganguly. Yes, sir. Yes, sir. Yeah. This one. Thank you. Also with us is Abhishek Manu Singhvi, who really needs no introduction since every major case in the country at the moment seems to somewhere revolve around India's preeminent constitutional lawyer, Congress MP, author, and someone, a man of many parts. Give him a very big hand, ladies and gentlemen. And my third guest is someone who currently is the Attorney General of Assam, so has an inside view into what happens in the relationship between the executive and the judiciary, because he's Attorney General of Assam. Devajit Saikia, Advocate General, welcome. And he's also a cricketer who played for East Zone at the same time as Saurav Ganguly as a wicketkeeper batsman. So the Rishabh Pant, long before Rishabh Pant, there was Mr. Saikia. Ladies and gentlemen, welcome to our next focus, which is the fine line between judicial overreach and executive inaction. With our focus particularly on the judiciary, I'm joined by Justice Ashok Ganguly of the Supreme Court, formerly of the Supreme Court, Dr. Abhishek Manu Singhvi, the country's leading constitutional lawyer and Congress MP, and Devajit Saikia, who's Advocate General of the Government of Assam. Thank you all very much for joining me. I'm going to start with the most contentious issue at the moment, which is the manner in which the judges have been making observations, especially in the Nupur Sharma case. Why don't you take it up, Dr. Singhvi, since you are at the moment in the heat of all that happens in the Supreme Court? Did the judges exceed their jurisdiction by making observations in the Nupur Sharma case of a kind that, according to critics of the judiciary, have virtually put her in the line of fire?
Let me make it pointed and short. The answer is no, Rajdeep. I see it a little differently than what you have been seen commenting on this issue. Whenever a litigant initiates an action in the Supreme Court, he takes a concomitant risk. The risk is that he is invoking the jurisdiction of the court, as Nupur Sharma was, for some relief. The risk he or she takes is that the court, while dealing with the matter in the course of questioning, eliciting the truth, giving their views, there is an interactive participatory process. Nobody, least of all the judges, claim it to be binding. Nobody, least of all the judges, say that what we are saying is a judgment. But you cannot, once you are the one who has invoked their jurisdiction, prevent them from participating and dealing with you and saying, look, and in Nupur Sharma's case, people forget this, we are dismissing your plea, which is based on the Arnab Goswami judgment, because we think that the Arnab Goswami judgment does not apply to you. For the following reasons, A, B, C, D. You set the country afire, you said this, etc. Now, this is a perfectly legitimate interactive process, and I think it is being distorted by suggesting that the court was at all intending to make binding observations. It doesn't bind any future thing. It doesn't affect Nupur Sharma's rights in a legal sense. Lastly, equally wrong is to then lampoon these judges, to stigmatize them, to attack them, to deal with them in social media, as partly in an academic sense Justice Pardiwala said in his lecture, because this is misunderstanding the process when you are arguing a matter. If you have such delicate toes and delicate fingers, then don't go to the Supreme Court.
So are you saying, therefore, it is not judicial overreach according to you? She and her loose tongue have set the entire country on fire. She has threat, or has she become a security threat the way she has ignited emotions across the country? Are these observations that do not constitute, according to you,
judicial overreach? No, because they are
overreach?
saying that we are making these observations to dismiss your request. A request was to transfer all the matters on the basis of the Arnab Goswami judgment. So what the court is saying is that according to us, the Arnab Goswami judgment does not apply because we believe that you are disentitled to relief because you made inflammatory comments.
So you're saying explanations of a judgment should not qualify as judicial overreach. You agree with that, Justice Ganguly? Do you believe judges should be making these observations in highly sensitive matters or just give the judgment?
Well, before answering this, may I say one thing? These days, what is happening is most of the oral observations are reported and not the order which is passed. That is an unfortunate way of reporting things because what is reported is something which is sensational. You see, as I agree with Manu Singhvi, that the mere oral observation is not binding on anybody because the judges' thinking process, judges were thinking aloud. They were there before passing any order. I can say from my experience, there has to be a thinking process which is reflected in the reasoning in the order. What is there in the reasoning of the order, that will bind, and that is never reported.
But
possibly in this case, I do not, correct me if I am wrong, the learned lawyer, Mr. Maninder Singh, was appearing for Mr. Sharma, Mrs. Rupur Sharma. That learned lawyer withdrew the petition, it was dismissed as withdrawn. The learned lawyer never risked the situation of getting an order, adverse order. But whatever has been observed by there is some truth in it.
But may I stop you for a moment? Because, you see, all of this comes on the back of, you said these were observations. There was a written order just a week before that in the Teesta Settlement case, where the judges say, people keep and Teesta Settlement was a co-petitioner in the case. The judges say people kept the pot boiling for ulterior design and all those involved in this abuse of process should be in the dock and proceeded against as per law. This is in reference to the Gujarat 2002 case that she had raised. A day later, she gets arrested because the sense is the judges in a case where I've gone as a petitioner is now virtually telling, not only dismissing the petition, but also virtually encouraging the police to go and arrest her, which is exactly what happened a day later.
This is very unfortunate. And on this, I have heard something said by Justice Lakur, one of the retired judges. And I entirely endorse his views. The judges should make it very clear whether they actually meant the arrest of Teesta. This kind of observation in a written judgment is very, very unfortunate, uncalled for, and without a precedent.
So you're making a distinction between the Teesta Settlement case, where you're saying because it was part of the written order, you are troubled by it. But in the case of Nupur Sharma, you're saying these are mere observations. They should not be seen, therefore, as judicial overreach. Am I correct?
Yes.
Yes, Dr. Singhvi.
I think your own example illustrates the vital difference. They were not only part of a written order, it's not merely the writing which matters. It was an essential part of the judgment. It's a 50-70 page judgment. An essential part is the para you read out. Now the reason it is objectionable is the following. First of all, the judges have a right to dismiss the claim filed by Mrs. Zafri. They have the right to say that it is unmeritorious. This para, A, is part of the main reasoning. It is not an observation. B, it goes far beyond by attributing motives to the initiation of the complaint. And C is the most important. Everybody knows it's the best kept, least kept secret that the government is raring to go at the leash to go against this person. These observations give the government the license to unleash a blitzkrieg of action against this person. The least the judges should then have done, and that's my fourth point, is to issue a clarification. They should have said, this para is not intended to be a license this way or that way about me going and arresting him or him arresting me.
You know, but Mr. Saikia, and you're with Advocate General appearing for a government, part of the problem is the sense that these are seen to be increasingly political cases. And the moment judges enter and observe, make observations on political cases or pass written orders, it's a minefield out there. In a society that is polarized, the judges seem to be also getting trapped in the polarization that takes place. So on Teesta Settlement, whatever our views on her are, tend to influence how we see the judgment. Similarly on Nupur Sharma.
That is the problem. Nowadays, it is the problem creates with the reporting. Now the deliberations, earlier the final judgment is in the news. But nowadays the deliberations between the judges and the lawyers, it comes into the newspaper rather than the judgment itself. The judges take lot of questions to the lawyers to go to the root of the matter. If you take the example of during the COVID time, Madras High Court, they have put some questions and ultimately the Madras High Court opined that Election Commission of India is the murderer because of the spike in the COVID cases, which was not the case. In most of the other states, like in Maharashtra, there was no election. But even that, few states were having election, but the judges during the deliberation made a off-the-cuff remark. That is reported much more than what was finally the outcome of
No,
the
so are you blaming the media for reporting
Yes.
the off-the-cuff remarks made by
Actually,
judges?
that
Are you
is the
saying the
problem.
media should only report the final judgment?
Exactly, because the judges want to know the mind and the root of the case, to know what exactly is the petitioner now in this case of Nupur Sharma. She wanted that all the cases should be together. In that case, certain remarks were passed to know what exactly she was doing, and in that outcome, certain off-the-cuff remarks were made. And that was highlighted, and that is why I do not want to enter into the chain of the reactions, counter-reactions, overreactions, all these things. But the thing is that end of the day, we have to go by the pleadings and what was argued.
You know, because interestingly, taking off from what Mr. Saikia said, Justice Ganguly, we are in the age of social media. Even what a judge says today immediately becomes a trend, on Twitter. And suddenly the judges, their motives are questioned, and it becomes a much larger story possibly than it would be 10 or 20 years ago. 10 or 20 years ago, we didn't have social media. That's the point that Justice Pardiwala has made in the context of the Nupur Sharma case. Do you believe, therefore, judges are under greater pressure, or should the judges themselves be showing greater restraint when passing observations of what are seen of a sweeping nature, as in the Nupur Sharma case? Should they be more conscious that we are in this multimedia age in a manner that perhaps you were not when you were in the Supreme Court?
Well, I am reminded of a very famous remark by Lord Cecil, sober as a judge. You see? So judges should always exercise restraint. There is no doubt about that. And they should always be careful of the fact that these days reporting takes a different turn. And it is very difficult to restrain the reporters. They also have a fundamental right to report. But at the same time, reporters also have a responsibility to ensure that administration of justice does not suffer. Because many times there are judgments. One of the judgments was by the Honorable Justice, Chief Justice of Supreme Court, Justice, I forget his name, before Justice, he was the Chief Justice after Justice K.G. Balakrishnan. He is one of the finest judges. He has given a judgment balancing these two aspects, the importance of the case, the importance of fair trial, and the right of reporting. So that judgment strikes the balance that where the reporter should also maintain a restraint in the interest of fair trial, an interest which is a part of administration of justice, which is also very important in a democratic country.
You know, we're looking at the moment at the higher judiciary.
Yes.
But let me for a moment look at the lower judiciary. We've just seen what's happened in the case of Mohammed Zubair. This is someone who was arrested for a 4-year-old tweet by the police. Then the judgment apparently, or the order extending his judicial custody by 2 weeks, is apparently leaked to the media in advance. The police apparently leaks it. And the police has added fresh provisions, with the result that he now faces not just charges of his tweet, but also under FCRA and for allegedly removing evidence. Is there a worry that what is true of the higher judiciary is even more amplified in the case of the lower judiciary? In the lower judiciary, the pressures today on the judges perhaps are even greater, because they simply are are even closer in a way to the executive, or dare I say the criminal, the policing system. Yes, go ahead, Dr. Singhvi.
Rajdeep, there are 2 or 3 facets here. It's a mixed bag. Actually, in many cases, I personally believe the lowest judiciary, the trial courts, have acquitted themselves better than the High Court and the Supreme Court.
That's a report. You're saying the lower judiciary has acquitted itself better than the high courts.
You take an outstanding example of the Delhi riots. The trial courts have repeatedly come out in favor of free speech, in favor of better policing, in favor of fairness, in favor of prosecuting people irrespective of their affiliations or religion. Frequently, that has not been done by the higher courts, or the higher courts worse still have intervened to reverse that. And there are many judges, I don't want to take individual names. But we have to discuss a more structural thing. I mean, these are all examples you are giving.
Yes.
The real point is, Rajdeep, at least I make no bones about saying so, there has been, and you have to accept it, a certain climate of fear and hesitation created. And that has permeated also the judiciary, and that includes from the top to the bottom. There is hesitation. Secondly, the approach is that you forget that the process is the punishment. भाई अल्टीमेटली राजदीप छूट जाएगा, ये गलत केस है, इस केस में कोई तथ्य नहीं है तो ठीक हो जाएगा. But what about Rajdeep going through the process? The initiation is the problem, and that is what the courts fail to realize. They have to nip it in the bud. The courts have to not look upon justice only as a curative ex post facto thing, but start giving strictures, start making strong comments so that preventive justice starts happening. The police officer hesitates before he books you. Now just take Zubair, it's a sub judice case, so we should not talk much about it, but I mean a 4-year-old tweet, even assuming it is objectionable, can be dealt with without arrest of this kind.
So who's responsible? You just now said
I'll
there
tell you
is
straight
there
away.
is fear.
Yes.
You're suggesting the judges are almost afraid,
Of course.
in a way of going against the executive.
I cannot, this is not a
You did
general
not use
comment.
but you said fear. Fear of whom?
Absolutely.
Fear of what?
No. There is an element of fear. There is an element of hesitation. There are transfers. There are cases where your promotions or your appointments are held back. There are any number of cases where, for example, in the same batch, the batch goes up for appointment. You make two categories out of it. You allow one, you keep back the other, and you appoint the next batch after 1 year, having made that batch lose 1 year of seniority. That's happening. The second,
I will press you again. You are
Absolutely.
saying something very serious. You are saying
And candidly
judges are
and
afraid
openly.
of going on the wrong side of the executive.
Take, for example, the number of cases pending where, despite 2 7-judge judgments, a second recommendation is reiterated by the collegium. So I recommend him. His name goes, it is returned. I recommend him a second time. The judgments say that the executive has zero power. I have written this more than 20 years ago, that if you were to issue a notice of contempt, not to the law minister but to the law secretary, in one case it would stop. Why are the judges not issuing a notice of contempt that after our second recommendation, how are you holding his name back? So I blame as much the judiciary as the executive. The executive will play this game, and I'm not talking politics, Rajdeep, it can be executive of any color. It will play this game, but the judges who have arrogated to themselves the power of the collegium should then have the accountability of the collegium that they should walk the talk till the last mile. And the last mile is saying, look, I've issued you a second recommendation. You have not done it for 6 months. I'm issuing a notice of contempt.
Mr. Saikia,
Yes.
you agree with that? Do you
I
believe
fully
that?
I most humbly disagree with it, because recently, if you know, the Jignesh Mewani's case in Assam,
Yes.
for a tweet, he was arrested by a police station of Barpeta. He filed an application for bail. The Chief Judicial Magistrate rejected his bail application, and it was challenged before the district and session judge. The district and session judge, only on the issue of bail, whether the bail was rightly rejected or it was not, gave a 29 pages judgment. And where he had crossed all his briefings, nobody's case was that there should be a constitutional debate, there should be a constitutional amendment. He went far ahead and said all the things against the running government, and including the democratic principles. 29 pages judgment in a simple application of bail, which was beyond the brief, neither it was argued nor it was in the pleadings. And this is just the reverse case in Jignesh Mewani's case in Assam. Ultimately, the Honorable Guwahati High Court has stated all the observations made in that 29 pages judgment.
No,
This is just the reverse, was my learned.
It's a reverse of what
Reverse.
has happened in the very other cases, the Jignesh Mewani case, where he was picked up by the Assam police.
Exactly.
Late in the night from Gujarat, brought to Assam, then again fresh charges are made. He's moved from Kokrajhar to Barpeta.
That is
So,
a separate, on the way, there's something
you see, the
happened. That is a
question,
separate-
the question, Mr. Saikia, is that when there is executive overreach,
It is not
when
the
the
case.
executive is seen to be behaving in a manner that a citizen's rights are being denied to him or her, why should the judiciary not intervene?
No, the thing is different. Exactly, the thing is different. If the person who is arrested misbehaves with a lady police, whether the executive should be lie idle,
Many believe these charges of Jignesh Mevani were specious. The Assam government was under pressure to ensure he was kept in jail for a long time. This is precisely the problem.
It was a case of 10 to 15 days issue. How can it be?
No, suddenly new charges are added or you are
New
misbehaved.
charges are added in a different police station, in a different district. On the way, he misbehaved. And
Are you really defending Mr. Saikia as
No,
Advocate
I'm
General? What the
defending
Assam police did
No,
with Jignesh Mevani?
Now, if you look at the sequence of events, 3 days after he was released from Assam, he was convicted in Gujarat for 2 years.
That's in another case.
That is another case. So that means that person is not having a very clean record.
No, I just want to say one thing.
You know, the Assam police, by the way,
what about the Gujarat police?
arrested Jignesh Mevani in Assam because someone in Kokrajhar filed a complaint that they were upset with the tweet that he had made against the Prime
In
Minister.
Kokrajhar, but while in Kokrajhar, he was taken on the way in Barpeta, he misbehaved with a lady police.
Okay.
No, you are asking an unenviable question of my friend. He was the Advocate General perhaps then. Or,
No, he is the Advocate General.
No, at that time also, and he has to defend that case. So that's an unfair question to ask him. But let me tell you 3 facts about Mevani's case. 1, he is picked up from an Assam complaint from Gujarat and taken there. 2, he is actually given bail, and let me accept my friend's comments about the fact that the judges made, the trial court judge made a lot of comments.
Yes.
The High Court stayed those comments. But the High Court did not deny bail on either of the charges. The High Court, including the trial court and the High Court, both found that the second charge was equally baseless, the woman police officer's harassment, and he got bail. Now there cannot be a more blatant example of a cooked up case. I'm not talking about, individual states, etc. The point is not that. The point is, so in the Mevani case, he got bail, the court did justice. What has the court done to send out a message which stops this happening again and again? Because Mevani is not punished finally. Mevani is punished by those 15 days. The process is the punishment. The court must realize that they must ensure that the process is not repeated every time by giving preventive strictures or strong remarks about police officers who must then hesitate. How long it took for the Chief Justice bench of the Supreme Court to stop sedition? Suppose they had done what they did on sedition at least 1 year earlier. Can you imagine the kind of cases, Rajdeep, on which sedition is filed? I can genuinely tell you that now any of us tweets, we genuinely think twice whether this could be seditious.
No, the point I'm making is that there seems, Dr. Singhvi, to be no consistency. For example, there is a case of Tejinder Singh Bagga. He's a BJP leader who the Punjab police comes to his house to pick him up because he has allegedly passed remarks against the Delhi Chief Minister Arvind Kejriwal, and now there is an AAP government in Punjab. Eventually the court sits at midnight to give him relief, to give him protection. So in one case, protection, the court will go out of its way to ensure protection as it should. In other cases, the person will spend weeks in jail. We had a case in Maharashtra where a woman actor has made certain comments about Sharad Pawar. She has spent 31 days or 41 days in jail in judicial custody for remarks that she made about Mr. Pawar. Now, my worry therefore is that the notions of free speech become selective. When there is a Maharashtra government, which is, the moment the government has changed, the police have said, yes, we were wrong in arresting her. I mean, if the police, is the police the problem, which is working under the instructions of the executive, and therefore, because the police has no independence, we'll have more and more such cases in the country.
What is sauce for the goose is sauce for the gander. You will have more, if the ruling party does egregious blunders, you will have unfortunate reactions from state governments, and I would condemn both.
No, in this state, we've had a YouTuber, Mamata Banerjee, claimed she had no knowledge of it. The fact is a YouTuber was arrested and brought from Goa to Kolkata because of comments that he had made about Mamata Banerjee. So I'm saying this seems to be, it's a disease that seems to be spreading, Dr. Singhvi, right across. You're a politician also. Are the politicians the problem?
No,
you want to settle your scores and then you use the police to settle scores.
There is no doubt that politics is the root of this, but it is very ivory towerish to think that the police will not do it or politicians will not do it. I think there has to be consistency. The crucial missing element here is consistency of judicial verdicts. If there is a pan-India broad consistency of judicial verdicts, it will stop within 1 month. Problem is that we don't have consistency of judicial verdicts even at the High Court and Supreme Court level.
You agree with that, Justice Ganguly, that there is a lack of consistency, and the fact is bail not jail is a well-established principle, and yet you've got people for comments, for tweets, being put in jail for a month, for 40 days. In this case, in Zubair's case, for a 4-year-old tweet. In Ketki Chitle's case, because she made a comment about Mr. Pawar, a 2-year-old case is raked up and she's put in jail.
Well, I would say that judiciary should be much more vigilant in protecting individual liberty and freedom of speech. I cannot make comments on individual cases, but this is something where the judiciary is, I think, is slightly not discharging its duty properly. I shall tell you, I mean, for a particular view of a learned judge, see, it happened in Bombay. You might be knowing. A learned judge acquitted an elderly person on the ground that without a skin-to-skin contact, there can't be any conviction under POSCO. Mm-hmm. That was judgment of a learned High Court judge. You may take a different view. That judgment can be overruled. But for taking that view, the tenure of that judge was not extended. And she had to resign. I mean, she goes back to the post of a district judge. This is unfortunate. For taking a view, which may be a possible view, which may be a view with which we do not agree, but there is executive pressure, and unfortunately the judges succumb to it.
No, but how do you ensure consistency in judgment? You're saying that we must ensure protection of individual liberties. I think we all agree with that.
Yes.
But when judges do not do so, and are consistently not doing so in state after state, I start wondering.
One of the, if I may say so, one of the very signal illustration is that Ajodhya High Court judgment. You see, you have seen a mosque standing there for ages. In 92, the mosque was demolished. The whole Supreme Court said in Ismail Farooqi case, that's an act of national sin. Now demolish it, and thereafter by a long-winded judgment without much reasoning, you hold that on that place will come up the temple. I think that is very great respect to the Honorable Supreme Court. I've said that before also. This is a total misreading of constitutional provision on freedom of religion. That is the beginning. If this can happen with Supreme Court, and you find the learned judges of the Supreme Court who delivered the judgment, nobody gave his name. Nobody ventured to say that I am the author of the judgment. But you have heard the Honorable Chief Justice saying that for delivering the judgment, the learned judges went for a dinner, they dined and
you're right. You're absolutely right.
And the judges could not put their names, which is very unfortunate. I have also some experience of being a judge for 18 years in High Court and Supreme Court. This has never happened.
No, but you tell me, you're critical of the Ayodhya judgment.
Yes,
look at it from the court's
for very good reasons.
Look at it from the court's point of view. Here is an issue which has been simmering for years, for decades. The executive is unable to resolve it, unable to find a solution to it. What do the judges do? What should the judge? Are we saying that the judges, therefore, whenever there is these sensitive political cases, should step out and say, look, you resolve it. Let Parliament resolve it. Why should we get into it in the first instance? Is that what you're saying?
No, I say the judges should be true to their oath. The oath is to uphold and abide by the Constitution. When you're asking what the judges should do, the judges should be true to their oath in the real sense of the term. They must uphold the Constitution regardless of who is there.
The limited point I'm making is that do you believe that given the fact that more and more politically sensitive cases now come to the highest judiciary, those cases in which you have one view on the Ayodhya judgment, there'll be another judge who has a completely different view to you. Now, given the polarized atmosphere in which this country exists at the moment, should judges be very, very careful in such cases and say, look, we are not going to rule on whether there is we are not going to rule on whether on the temple mosque issue, That is for civil society. That is for the executive to settle. Please don't bring these judgments to, don't bring these issues to the court. Should they say that? Should they say, look, whether the Gyan Vapi mosque was a mosque, whether there was is a mosque, whether it's a temple, invariably the moment I pronounce on it, I am getting into very, very dangerous territory.
Look, Rajdeep, I don't think I don't think anybody is saying the judges should avoid issues. On the contrary, avoiding issues for judges is bad and wrong. Personally, I would say, one, judges have to show that they are not influenced externally or intrinsically by the ambience created around them by A, the media, and B, clearly by apparent or real government pressure. Now, we all know, it's like an elephant. You may not be able to define an elephant, but when you touch it, you know it's an elephant. You can pinpoint many, many cases where you get the feel that this is done because they believe that there is a political angle and it's easier to take the easy way out. And that is happening increasingly, whether it is happening because of fear, whether it is happening because of dossier raj, whether it is happening because of an overall climate is a larger issue. And I also believe that in such matters, the compulsion to conform is the biggest inhibitor of free speech or independent judicial thinking. The compulsion to conform is a compulsion created by external forces like the media. You will say what the media thinks should be said or is right, not what is necessarily right. So that compulsion to conform or political pressure has to be eschewed completely. And lastly, I think it's the contextual thing. Take, for example, Ayodhya. And I'm certainly not speaking of Ayodhya judgment. That's a done deed. It's done and dusted. I'm not even talking of the merits as Justice Ganguly has talked. But a correct judgment, a fully valid judgment, and I think there are lots of issues on which people will disagree with Ayodhya, can still be put under the cloud and suspicion because of the context surrounding it. What happened after the judgment to the presiding judge who was part of that bench? What, does it not lead to unnecessary question mark because of the context of how you behave, how you conduct yourself? So that is what creates a problem for the judiciary.
You know, but the part of the problem, Mr. Saikia, is the fact that, and I'll give you a list of cases today which are seen as judicial overreach. Ban on Diwali crackers. Citing pollution is decided by judges in this country will decide whether I can play crackers or not. Banning the use of private vehicles after 10 to 15 years. Cancelling telecom licenses. Supreme Court even in India deciding on allegations of corruption, match fixing, deciding there will be a Lodha panel which is appointed which will then decide how cricket is to be administered in this country. They decide on the height of dams. Every issue goes to the judiciary today and the judges are more than happy to have an expanded scope of judicial review. You agree with that or not? Or should they be limiting the scope of judicial review and saying, look, we are not going to get into issues whether firecrackers should be banned or not. The executive must decide that.
That is where precisely we have to look into it. If we look at the constitutional scheme of things, the thing is very clear. Whose role is to lay the law? It is the legislature, implementation, the executive, and finally the honorable judges have to interpret the law and its implementation. Now look at the case of Lodha committees. Whatever recommendation they have given, ultimately it has all diluted. Today nothing is there. And Honorable Supreme Court, while dealing with the Lodha committee's case, has finally diluted the basic law which was prevailing under which the BCCI was registered, the Tamil Nadu Society's registration, or the Delhi DDCA. It is under the company's law. A new constitution has brought into force and nothing is working now, and again a review application is pending before the Honorable Supreme Court. Have you seen any changes in the BCCI? You will not see. If you take the example of national anthem.
No, in fact, a judgment has been reserved on the continuance of Saurav Ganguly and Jai Shah. Even though their terms are over, it continues. The Supreme Court has reserved the judgment for 18 months.
I stand you corrected. The final judgment was delivered 2019, 8th or 10th of August. Thereafter, a fresh review application is going on.
That's right.
And series after series, the case is continuing. Adjournment, some sort of hearing had also taken place. But finally, the review application is still pending as on date. The thing is that till now, Lodha Committee's original recommendation and prior to that Mudgal Committee's report, what was there in the Mudgal Committees? Basically, everybody wanted that the corruption in BCCI, the match fixing, and whether it should be under RTI. All these things.
No,
were
should the
issues.
judges be getting into this space at all?
Absolutely. This is where
They should be getting, they should
no,
monitor
they
how-
should not.
They should stay away.
Not. They should not run the sports body. We already have a sports code in place.
You know, because, I'll give you another, you're saying legislation should be left to the legislature.
Exactly.
You know,
that
but-
is the scheme of the constitution.
Sure, but Dr. Singhvi is in parliament. The fact is, look at what happened in parliament with the farmers' law. Parliament passes the farmers' law, there is an agitation. Eventually, the judiciary steps in and says, we are putting a stay on this law for 2 years. Is this the job of the judges? Are the judges, the worry that I have, Dr. Singhvi, and I'll then come to Dr. Ganguly, is the worry that judges are playing God, and we are more than happy to allow them to play that because the executive has failed in its responsibility and so has the legislature.
What-
Executive inaction and legislative failures are leading to judges playing God.
There is no doubt that India has the most humongous judicial review, as they used to say about the British Parliament, that short of declaring a man to be a woman or a woman to be a man, the British Parliament can do everything. I think it applies more aptly to Indian judiciary, short of doing that. But what is the systemic point behind what rightly my friend said here and what rightly you said? What is the systemic point? The systemic point is there is no consistency. It comes back to the same point. We joke that there are now 16 courtrooms in the Supreme Court, but there may be 32 Supreme Courts functioning.
16 courtrooms?
But there may be not one Supreme Court, but 32 Supreme Courts functioning, or maybe at least 22 Supreme Courts functioning. Do you know the variation? I once jocularly told Justice Pathak that if I was to make a hypothetical exam question and circulate it as a putative SLP amongst all the benches, you might get 7 different results. Now, the reason is that when different people speak with different voices, the strength is diluted and there is no effect. Secondly, we do not have post-decisional social or statistical audits. You do a CNG crusade in the Supreme Court. After 5 years of that judgment, you don't do a statistical audit in Delhi or elsewhere. I'm giving an example to see whether it has been beneficial, to what extent it is beneficial, to what extent are the disadvantages.
Should judges be audited? Should their
Not
judgments
judges,
be
no,
audited?
no.
Should their judgments be looked
for
at?
For PILs, the post-decisional ground audit must be there statistically. And third is the clawback. There are any number of judgments, and you rightly gave the example of the sports case, where the judgment comes from a very high platform, from the mountaintop. And then immediately thereafter by successive benches, when Justice Ganguly has retired, my bench, when I have retired, his bench, will claw back, dilute. Either don't give the Ganguly judgment. If you give the Ganguly judgment, stand by it and reinforce it. The problem is that different benches are, now this is exactly what is happening in the cricket matter. There is a complete clawback. So these are all elements of lack of consistency which actually weakens the Supreme Court. The Supreme Court being an exemplar, an apex body, it weakens the whole judicial system, and weakening the judicial system means that everybody, it's jungle out there, every trial court can do what they like, every high court can do what they like.
You want to respond to that? Look at even in the Gujarat riots case. In 2004, judges pass observations like Nero was fiddling while Rome is burning. Today, 18 years later, the petitioners are being accused of keeping the communal pot boiling. This is, in a way, the same Supreme Court, which changes its mind as governments seem to change, or changes its mind as the ecosystem, to use a word that the BJP likes to use at the moment, keeps changing. Is that true? That judges are being influenced by what is happening around them, Justice Ganguly?
Well, as a former judge, it is very difficult for me to accept that judges are influenced by the changing political scenario. I will never say yes to this question of yours. But you see, you ask me the question why the Supreme Court has become demigod. Why? You see, there is a declining matter of confidence of people, both in the executive and in the legislature. You are talking of the BCCI thing. May I just remind you of one thing? As far as I remember, there was an election about BCCI presidency. And one side was Mr. Sharad Pawar, and the other side was Mr. Dilip Venksatkar, a former captain and a very renowned cricketer. I don't know anything about the cricketing skills of Mr. Sharad Pawar. But Sharad Pawar won, and Mr. Venksatkar lost. These are the reasons. These are the reasons why people lose faith in the efficacy of this system. and they go look up to judiciary.
No, but why should the judiciary step in? If Sharad Pawar has won his election as BCCI president, you don't like the idea that Sharad Pawar has lost to Dilip Venksalkar?
No.
You
As
put in
against
certain-
whom? As against whom? It's a cricketing body. It's a sports organization. And
But
we
is it
see-
the job of judges to,
No,
administer a
may
sports
not be
body?
so, but that is the reason why things are put before the judges. And where the judges, whether there is overreach or whether there are some excessive interference with the functioning of the body, these are matters of argument.
But you made a point just now.
But you see, more and more cases, you just think of the Ayodhya case, not this one. Previous Ayodhya case, when that thing happened, when the masjid was demolished, what did the central government do? They asked for a presidential reference and asked the Supreme Court to decide whether there was a Hindu structure beneath the mosque. Can the court decide it? But they shifted the burden to the judiciary, passed on the buck. And of course the judiciary did the right thing by refusing to answer that presidential reference.
But that's exactly what also happened, isn't it, Dr. Singhvi, which you cleverly avoided in the case of the farm legislation. The government was worried that these farm protests are taking place. What do? We tell the Supreme Court, try and ensure that the matter is deferred in a way for 2 years by saying, put a stay on the...
I agree. I don't avoid the question at all. I made a comment then contemporaneously. I don't know what the truth is, but the Supreme Court has to manage perceptions about it also. The clear perception at the time of that order was that the Supreme Court is giving a breather or a window to the government to try and quieten things down because they were reaching a peak. Now, the way the court did it was by two errors. Error one, it stayed a legislation, which is rarely done on the first or second date after it. It's never done, in fact. Second, while staying it, it gave a direction that you shall negotiate, you shall talk. Third, it created virtually, it did not do it directly but indirectly, a committee of sorts to do that. Now, this was actually a left-handed gift to the government, but it was totally beyond the law. Now, when you put your hand in the thicket of a beehive, which is a political beehive, then you are bound to get bitten by bees.
Therefore, in conclusion, Mr. Saikia, while issues like sports bodies, the Supreme Court is more than happy to intervene. On issues that really consider civil, individual liberties or major issues of public importance, electoral bonds, that matter keeps dragging on for years. Article 370, people, including politicians, are arrested for months on end. People have been arrested under UAPA. Activists, habeas corpus cases. People have been arrested for months on end. The court won't intervene. So, it appears again that the court is very, very selective and politicized. Is the court politicized today?
I would answer it in a different way. Now, most of the time is used for this kind of issues. Basically, we are leaving the main issues to be addressed. When the Honorable Court is taking so much of time in taking these political issues, which actually should be addressed by the public in the ballot war, not in the court. So while taking the issue, like take the example of national anthem, so much time was used for directing that the cinema halls should have the national anthems and all. How can you implement it? It is diluting all the laws which are governing the flag and all. The thing is that all this confrontation between legislature, executive and the judiciary will take a normal solution if everybody restricts their position as per their domain given by the Constitution. The framer of the Constitution are very clear.
But if also
defined.
each institution does not abuse the process of the Constitution, the problem at the moment is because the executive
Now
is being
suppose,
accused of abusing
I
the
take
Constitution.
one thing. Suppose the Honorable Supreme Court is not giving the proper judgment. Who will judge the Honorable Judiciary?
Let me leave that as the final question. Who will judge the judges? Justice Ganguly, who will judge the judges? You judge everyone else. Who will judge you?
The people of this country.
No. How will we judge you?
Of course you can.
They are not accountable to
Of
anybody.
course you can. I mean,
They're not accountable to anyone.
No.
advocate
They are
general-
accountable.
They are not accountable.
There are impeachment procedures, and that is taken
That
up
is
by
a very,
Parliament.
very Herculean task.
Yeah, Herculean task.
No.
Dr.
You don't say
Singhvi-
they are not accountable. They are accountable.
Let me give Dr. Singhvi the final word. Who will judge the judges?
There's no easy answer. The Supreme Court is not final because it is right because it is final. Ultimately, judges are judged first and foremost by their conscience, second by the bar of public opinion, third by the bar which practice before them. And a combination of all three, let me tell you at the end of the day, there have been judges who have done blunders, who have done errors. They have never gone down in history as judges you remember. Some great judges have, and judges who have stood by their conscience and by their oath, as we said just a while ago, have always shone. And that's a retrospective judgment of history, which you have to live by. You cannot have a Supreme Court, as they said, if you have a Supreme Court above the Supreme Court, 50% reversal would be there. You can't keep on having upper levels.
Okay, let's leave it on that. Maybe there is a need for judges to look within at their conscience and indeed the executive and possibly the legislature. Am I asking for too much? Am I being overly idealistic in the times in which we live? But for now, for this very, very enlightening discussion, Mr. Saikia, Dr. Singhvi, Justice Ganguly, appreciate you joining us at the India Today Conclave. Give them a big hand, ladies and gentlemen. That was most fascinating. Thank you.